This video blog is about joint patent collaboration as well as infringement, and this post is inspired by another article on Patent Leo, which is a blog dedicated to patent law. And in this particular post, the blog writer has brought up some of the conditions that are required in joint inventorship. This actually specifically states that an invention is made by two or more persons at the same time jointly, but it actually didn't require that these people who are co-inventors have to be physically present to work together or at the same time, or even that they have to make the same amount of contribution. And so I thought that this actually presented a lot of gray areas, particularly if a patent is brought to court. It's going to be something that's difficult to contend, and furthermore, in terms of ownership, I think it'd be very tough to say, who actually invented the idea or not. So, for example, if you had one person who contributed 1/10 of the idea compared to someone who contributed 9/10 of the idea, then do you consider both as joint authors of the patent, or do you consider the majority of the ideas coming from that person, meaning that the other person is actually the owner? So it looks like the rules state that they don't require equal amounts of contribution, which really creates a fuzzy line for what is considered joint collaboration for a patent. And this brought to mind some issues regarding the realm of mobile wireless, particularly given that all of these large companies we hear about, including Microsoft, Samsung, Google, Qualcomm, etc., who own thousands of patents in their patent portfolios, actually co-own and have some joint patents together. So we ask ourselves the questions then in litigation: who's responsible for the fees, and who's responsible for recognizing this on their P&L and their balance sheets? So it's definitely something that presents gray areas that definitely doesn't make the process of patent litigation any easier than it is.